Yes, Mr. Ryan.
My lords, my lady, good afternoon. Before I go back to the provisions of the scheme with which we are concerned, may I just say something very briefly about Malcolm? And it follows on from the question Lord Hodge asked of my learned friend this morning. I understand you should now have hard copies of the opinions of the House of Lords in Malcolm.
Yes.
And I think that the substance of the question, please correct me if I'm wrong, is whether the parties accept in this case that Section 15 really was aimed at putting in or implementing Lady Hale's dissenting judgment in Malcolm. The relevant passage, I think, her judgment starts at paragraph 42. There aren't page numbers, I'm afraid, in the copy that I have. You can see at the very bottom of the previous page, it has the heading Baroness Hale of Richmond, and then paragraph 42 onwards is her dissenting judgment. The relevant passage for my purposes, I think, is a few pages on...
68, is it?
Really 70.
70.
The heading others to whom that reason does not or would not apply, and that of course was that's a quote from the relevant provision in the Disability Discrimination Act as it then was, and the key point in Malcolm was whether the comparator that had been formulated in Clark and Novacold some 9 years earlier and that had been followed, as my own friend rightly said, ever since, was the right comparator, or whether a different comparator should be adopted. The majority in Malcolm found that it's a different comparator. It's essentially someone who does the same things as the claimant, but is not disabled. Baroness Hale, here, paragraph 70 and onwards, asks the question, well, who are the others? And if one goes over the page, paragraph 72, I think that this is the crux of it for my purposes. On closer examination, however, the decision of Clark and Novacold makes sense. There is also good reason to conclude that it reflects the actual intention of Parliament. So the substance of her dissenting judgment was, well, the Court of Appeal got it right in Clark and Novacold. I accept that Section 15 was intended to undo Malcolm, if I can put it in that way, and to re-establish the protection afforded under the approach suggested by the Court of Appeal in Clark and Novacold. So, to that extent, I do agree with my Lord Hodge's comment right at the start of my learned friend's submissions. Going back to the structure I set out just before lunch, I've already been through, albeit at some speed, the original benefit structure.
Do you accept that Lady Hale's opinion as a result is a good guide to what the policy was before, which this Act is designed to restore? You don't have to go that far in relation to every word. Maybe it's an unfair question.
May I have a think about that?
Yes, well, it's quite useful because, I mean, as always, she sets it out in fairly extensively. One of the key points is that the emphasis is really on justification. You should set a lower hurdle for the comparison, and then you will, on the other hand, justify.
The point in the distinction between Malcolm and Clark was simply who the comparator is. At that stage, a comparator was required. The dissenting judgment of Baroness Hale was essentially saying, well, Clark got it right as to who the comparator is. In Section 15, as I'll come to in due course, there is no need for a comparator, and indeed, as the Court of Appeal and the EAT found in this case, approaching the case on the basis of how a comparator would have been treated is not a permissible approach for a tribunal to take. And I'll come on to this in due course, but I say, as the EAT and the Court of Appeal did, well, that on proper analysis is how the claimant's case is being put in this case. But in terms of what the appropriate construction of section 15 is, it's a different provision, it's a new provision, and in that sense it isn't going back to precisely what section 3A of the DDA, the Disability Discrimination Act, provided, because that did require a comparator. As I said, going back to my relatively brief, I hope, discussion of the pension scheme in question, I've already been through the original final salary structure and the change in 2009 to career average revalued earnings, each year's pot being assessed separately and revalued with an inflationary measure each year up to retirement. A point that I can deal with fairly briefly, I hope, because it appears that Milona Friend has backed away from the way in which the case was put in the claimant's case. I think she's now saying, well, we didn't intend to put it that way in the first place. It's the amendment that she made to paragraph 65. And it also arises from a comment made by Lord Justice Bean in his judgment in the Court of Appeal. I can state it briefly. I don't think I need to take you to the relevant passage. CARE, career average revalued earnings, does not mean, and it has never meant, it's never meant, rather, in this or indeed any other scheme, as far as the respondents are aware or their advisors are aware, some sort of averaging of salary across someone's career and then using that as a multiplicand to calculate their pension on retirement. That seemed to be what the claimant was suggesting was the baseline or the neutral approach. The difficulty with that is, so say someone is retiring today, they have 5 years of service, their salary has varied from year to year, and I thought that the approach being advocated by the claimant was, well, you should somehow add their 5 years' earnings together and divide by 5, and that gets you the multiplicand. Well, that simply wouldn't work for a number of reasons, one of which is it would ignore any inflationary changes in the intervening 5 years. Salary 5 years ago is worth rather less than it would be today. But as I say, the claimant, well, plus that would have been an entirely new case, never put before this stage of this litigation, but it now appears Milona Friend has backed away from it, even if she intended to go there, so I can move on. Just to complete the picture in relation to the pension scheme with which this case is concerned and its benefit structure, 2012, so 3 years after the change of accrual basis from final salary to care, there were further amendments made to the scheme. It was closed to new entrants, so anyone starting employment from the 1st of January 2012 onwards simply could not join the scheme at all. Therefore, by definition, they could not accrue DB benefits. They were given access to a separate DC scheme. The inflationary measure used for benefit revaluation, so the annual revaluation to accrued benefits, was changed from RPI to CPI, again, typically a lower inflationary measure, and a similar measure adopted across the public sector and in many cases the private sector. And also what's been referred to as NPD, normal pension date, the date from which members of the scheme can ordinarily take their benefits without any sort of actuarial reduction, was changed from 65 to state pension age if higher. This tied in with changes to state pension age on a graduated basis. And in the claimant's case, given his age, that resulted in a change in his normal pension date under the scheme from 65 to 67. All of these measures were intended as cost-saving measures. As you'll see if you read the Employment Tribunal's judgment, the background was that the scheme was, and indeed is, in significant deficit, and a number of measures were taken, including the change to care and the further changes in 2012 to try and limit the ongoing costs of the scheme. Changing normal pension date from 65 to 67 is intended to mean for the vast majority of members that they have to wait another 2 years before they can receive their benefits. In the claimant's case, as we shall see, this in fact meant that he got an extra 2 years purchase on his ill health retirement benefit. So that change was in fact to his advantage, as it turned out. The benefit structure under this scheme, and again I stress this, it's part of the context in which this case has to be considered, was and is on any view a generous one, but also it has specific provisions for ill health retirement. There is no obligation on a pension scheme such as this to have any ill health provisions at all.
No statutory obligation.
No statutory obligation. My Lord, yes. There are a number of statutory conditions applying to pension schemes under the Pension Schemes Act 93, the Pensions Act 95 and later provisions, some relating to registration, previously called exempt approved status, some relating to contracting out, which has now been abolished, but none of those require ill health provisions to be put in place. And just pausing there, and I'll come back to this in due course, this is a claim under Section 61 of the Equality Act, and it's important to bear that in mind throughout this, because the way it operates is by a statutory override on the rules of the scheme. It implies what's called a non-discrimination rule into every occupational pension scheme, and the rules of the scheme need to be read so as to comply with the non-discrimination rule. And if they don't, trustees are given powers, statutory powers, to amend the rules so that they do. And the claimant's case is brought under Section 61, and therefore it has to be read through the rules of the scheme, not in some other freestanding way. The ill health provisions of this scheme, as I've said, certainly no statutory obligation to provide ill health provisions. This scheme could have provided that anyone incapable of continuing to work through ill health had to wait until their normal pension date to receive any benefits. Members generally, as I've said, can't take benefits without reduction until normal pension date. They can take benefits from age 55, which is the age, the minimum pension age for tax purposes. If you take benefits before that, it's treated as an unauthorised payment, and there are rather punitive tax consequences. But this scheme provides you can take benefits at 55, but they are subject to substantial actuarial reduction. So essentially normal pension date means what it says. This scheme has always provided what I say are, on any view, very generous ill health benefits. Rule 15.5 is the key rule for present purposes. It's set out at paragraph 16 of my case, page 86 in your bundle. It's part of the core volume. It's also in the appendix in the rules themselves, but this will do for my purposes. Paragraph 16 provides as follows: subject to sub-rules 15.3 and 15.6 and the GMP guaranteed minimum pension model rules, none of which need concern us, a member who has completed at least 2 years pensionable service who retires from service at any time before his normal pension date as a result of capital I incapacity. Again, I won't take you to the definition. The way my learned friend put it this morning was essentially permanently incapable of carrying on your job. I accept that broadly as an accurate reflection of what incapacity is defined as meaning. May be provided with an immediate annual pension if the trustees and the principal employer so determine. The pension will be equal to the member's scale pension. That is also defined, and essentially it's pension calculated in the way that I've already discussed under the care provisions, which would have been payable to him had the date of his actual retirement been his normal pension date, calculated on his final pensionable salary at the date of his actual retirement and his pensionable service up to his normal pension date. A number of salient features from that rule. To be eligible, an employee has to retire as a result of incapacity. There is no dispute, as I understand it, certainly since the EAT, it was disputed before the tribunal, but not since, that anyone who is eligible under Rule 15.5 necessarily must be disabled. So those who are eligible are a subset of those employees who are disabled, but some who are disabled will not be eligible for ill health retirement. If you are eligible, then benefits are calculated in a different way from normal. There has been mention in the papers that have been generated in this case of accrued element and enhanced element, and I think I am as guilty as anyone of using that terminology. But under the rules, Rule 15.5, it is a unitary pension that is calculated. It's a single calculation in accordance with the formula set out in Rule 15.5. And what the calculation does is it takes the care benefits, the career average revalued earnings benefits that have already been accrued by pensionable service to date of retirement, but instead of pensionable service being treated as ending with retirement, it's treated as though it had carried on for, in this case, many years up until normal pension date. And essentially the way the calculation works is this: for the last year of accrual, and you'll recall under the care accrual basis, benefits accrue year on year and are then revalued. For the last year of accrual, which would normally be pensionable salary in the last year up to retirement times 1/80th, and because it's the last year, there isn't any need to revalue it for inflation. But under Rule 15.5, what is done is, instead of multiplying it by 1/80th, the multiplier is adjusted so that it is increased by the number of years from the date of retirement to normal pension date. That is the mechanism of Rule 15.5. So in the claimant's case, what that resulted in was a multiplier of 29 point something instead of 1 over 80 for his final year of accrual. And in financial terms, his annual pension was more or less doubled, and his lump sum more than tripled over what it would have been just on the basis of accrued pension. He received his benefits immediately, at the age of 38, I think, rather than having to wait until normal pension date. He received them without any actuarial reduction at all, even though he was receiving them more than 28 years before normal pension date, and they're index-linked for life. There was evidence and discussion before the Employment Tribunal, and for your note, it's paragraph 25 of the Employment Tribunal's reasons, page 159. It's part 1 of the appendix. But the additional financial strain on the scheme, because under a defined benefit scheme, the question arises, well, if we're going to enhance someone's benefits, who's going to pay for it? The answer, the employer. The additional financial strain on the scheme was estimated at about £335,000, and that is the sum that the university, the second respondent, has to pay into the scheme to fund the increase in benefits under Rule 15.5. I've spent some time setting out the structure of the scheme and how it applied to the claimant, because in my submission, whatever the appropriate test, and I'll come to what we say Shamoon says about the test for detriment and whether that's the appropriate test under Section 15 in due course. But whatever the appropriate test to be applied, all relevant circumstances have to be taken into account, including the context in which the benefits are paid in a case such as this, which is brought under Section 61 in relation to a pension scheme. The Equality Act. As your Lordships and your Ladyship will doubtless be aware, the Equality Act 2010, it brought under one roof, as it were, a large number of previous separate anti-discrimination provisions, and indeed it introduced a number of new provisions, including Section 15, that I will come to in a short while. Malone Friend has already dealt with the structure to some extent. Again, I'm going to spend a few minutes, if I may, just filling in some of the gaps. The Equality Act is broken down into a number of parts. Part 2, which has the title Equality Key Concepts, amongst other things, defines a number of types of discrimination. Discrimination is the word used in many of them, also harassment, victimisation and reasonable adjustments, as we've heard, and I'll come to those in due course. That includes Section 15, but Part 2 doesn't render anything unlawful. Other parts of the Act render various types of discrimination unlawful in a number of different contexts. This is an employment stroke work case, but you also have Part 3, which deals with provision of services and exercise of public functions. Part 4, premises, what would have been the relevant part for Malcolm, were it brought today. Part 5, work. Part 6, education, and so on. And it's important in my submission to bear that in mind when one is considering the claimant submission that I think to summarise accurately, well, everything is funneled through to Section 39 and the reference there to detriment. Well, that with respect is simply not right. There are many other provisions in many other parts of the Act that render various matters unlawful, which do not funnel through Section 39 or indeed any other part of Part 5. May I invite you to have a look at the first authorities bundle, tab 2. Again, Malone Friend took you to a number of parts of this. It's page 469 is the start of that tab. And the first few pages here are selected sections from Part 2 of the Act. This isn't the entirety of Part 2, but it's a number of sections. Section 13 deals with direct discrimination, and subsection 1 is the crux of the definition of direct discrimination. A person A discriminates against another B if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. It's a less favourable treatment test. It requires a comparator. Something also to note, the causative element is because of a protected characteristic. It doesn't have to be a protected characteristic of B. So one has what's usually referred to as associative discrimination catered for here. So, for example, discrimination not because of the employee's protected characteristic, but say the employee's spouse or child or whatever. The next, at page 471, is Section 15, which is the key provision for our purposes, discrimination arising from disability. This is a section introduced for the first time in the Equality Act. It is specifically for disabled persons. It does not apply to any other protected characteristic. Person A discriminates against a disabled person B. So again, unlike Section 13, it is protection for the disabled person, him or herself. And then we have little a and little b, which you've already been taken to. A treats B unfavourably is the key issue in this case. What does that mean, and does it apply to the claimant? Because of something arising in consequence of B's disability. And as has already been mentioned this morning, that is a significantly lower threshold in terms of causation than under Section 13 or indeed a number of the other sections in Part 2. Part 17 is the next, page 472, pregnancy and maternity discrimination in non-work cases. That perhaps emphasises the point that these apply to all of the parts of the Act, not just the work cases. And if one goes over to page 474, section 18, this is pregnancy and maternity discrimination work cases. And subsection 2, a person A discriminates against a woman if in a protected period in relation to a pregnancy of hers, A treats her unfavourably. So again, we have the same treats her unfavourably formulation because of the pregnancy or because of illness suffered by her as a result of it. And subsections 3 and 4, again, one sees that the same formula, A treats her unfavourably, and so on. Section 19, indirect discrimination, different formulation. There we see it, subsection 2b, puts or would put persons with whom B shares the characteristic at a particular disadvantage. C, it puts or would put B at that disadvantage. So again, a different formulation. 23, I needn't bother you with. Over the page, 478. 26, harassment. Melanie Friend took you to this briefly this morning, but again, a different formulation of what is required to fall within this section. And 27, victimisation, page 480. Subsection 1, a person A victimises another person B if A subjects B to a detriment because of a protected act or A believes that B has done or may do a protected act. You haven't got in your in tab 2 section 20 or 21 of the Equality Act. They deal with reasonable adjustments. Again, that is a specific disability protection. It only applies to in disability cases, and it does not refer to detriment at all. The only reference to detriment in part 2 is in section 27. We then come, page 481 in tab 2, to extracts from part 5. Number of sections in part 5, you have 2 of them here. This is where, in the context of work, which is the context in which part 5 applies, certain acts which fall within one of the definitions in part 2 are rendered unlawful. Section 39, which is the subject of a large element of Melanie Friend's submissions in her case, certainly, deals with discrimination in the context of employees and applicants. And subsection 1 is for applicants. Essentially, mustn't discriminate in the arrangements made for deciding who to offer employment to and so on. Subsection 2 is those who are already employed. An employer must not discriminate against an employee of A's as to terms of employment and so on. And then little d is the focus of Melanie Friend's submissions by subjecting B to any other detriment. That is where one sees detriment referred to in section 39. Now, just pausing there, in many cases, an employee or a former employee or an applicant for employment will bring a claim saying, I have been discriminated against directly, say, and it also falls within section 39, and therefore it's unlawful. The claim is channeled through one or more of the parts of part 2, and then through section 39. And in those circumstances, whether or not the conduct of which complaint is made amounts to a detriment is clearly going to be relevant. But this is not such a case. If you turn over to page 483, and this is the last section I need to refer to in the Equality Act.
Just before we go there,
yes.
do we see in 39.3 and 39.4 the prohibition relates to victimisation in each case rather than discrimination? Is that significant?
My Lord, for the purposes of this case, I don't think it is. The structure of 39 is 1 and 2 render unlawful discrimination in any of the respects.
Therefore, deal with victimisation rather than
I
discrimination.
mean, is that a reference back to paragraph 27?
To section 27, it is.
Section 27.
It is. And indeed, section 40, which you don't have here, makes the equivalent provisions in respect of harassment. I think the point is that in part 2, discrimination means one of the forms of discrimination, direct, indirect, arising from disability, and so on. It does not include victimisation, hence separate provisions in section 39, 3 and 4 for victimisation, and in 5 for reasonable adjustments, section 20, and section 40, which you don't have here, renders...
My point is simply that reliance on the word detriment in 39.4 as telling us something about section 15 is questionable.
Yes.
If 39.4 is merely addressing section 27.
Yes.
It comes in 39.2, which is relevant.
But 39.2...
It would be relevant if this were a case that were brought under section 39, but it isn't. That's my point.
Yeah.
Many, possibly most, possibly the vast majority of cases brought before the Employment Tribunal under section 15 are brought on the basis of, well, I've been treated favourably in such a way as to comply with the requirements of section 15, and it is in circumstances that also fall within section 39.1 or 2, and say it amounts to a detriment, therefore it's unlawful.
But in that context, one gets first the requirement to show something is unfavourable, and then you get the requirement to show that there's detriment.
Yes.
So they both come in.
They do, on that sort of claim, yes. Yeah. But they don't come in on this sort of claim because...
that might be said to support the view that they are different. They're not saying the same
indeed,
thing.
and I rely on that, and there are umpteen judicial comments, albeit at lower levels than this, to that effect, and I'll take you to one or two in a moment.
Sure.
Page 483, section 61, still in part 5, chapter 2 this time. This is not in the context of someone bringing a claim as an employee or a former employee or an applicant for employment. This is something brought in the context of an occupational pension scheme, and it is a different route. It does not require one to go anywhere near section 39, and this is the provision under which the claimant's claim has been brought. Subsection 1, an occupational pension scheme must be taken to include a non-discrimination rule. Occupational pension scheme defined in the same way as the Pension Schemes Act 93, it includes this scheme we accept. And subsection 2, a non-discrimination rule is a provision by virtue of which a responsible person, A, must not discriminate against another person, B, in carrying out any of A's functions in relation to the scheme, or harass or victimise B. And little 3, subsection 3, the provisions of an occupational pension scheme have effect subject to the non-discrimination rule. And in terms of the bit that renders it unlawful, subsection 7, a breach of a non-discrimination rule is a contravention of this part for the purposes of part 9 enforcement. And there are also provisions for trustees to amend the scheme as needed to render it compliant with the non-discrimination. That is the provision under which this claim has been brought. It does not mention detriment at any stage. So in this case, brought through section 15 and section 61, it is no part of the statutory questions that the tribunal has to answer as to whether the claimant did or did not suffer a detriment. It simply doesn't feature. I said before lunch I would touch on the facts of the case, and I'll do so very briefly. The basic facts have been rehearsed a number of times in the documents, and I know your lordships and your ladyship will have read them, and I won't take up time unnecessarily doing so, going through them now. What I will say is that it is instructive in my submission when looking at the various cases that are relied on by the claimant in their case, and indeed the hypothetical examples raised by my learned friend in her speaking note and in oral submissions this morning, to look at the factual context in which those cases arise. We are concerned here with pension benefits and a pension scheme. We are not concerned with employment terms and conditions under Section 39. We are not concerned with sick pay. We are not concerned with attendance policies, bonus schemes, or anything of the sort, which in broad terms are aimed at rewarding employee performance or to encourage employees not to leave, or if they're on sick leave, they're designed to encourage the employee to come back to work. This case is factually very different from any of the cases relied on, the actual ones or hypothetical ones relied on by the claimant. Another point at this stage that I'll make is certainly on this side of the court, we are not aware of any other case, whether it was under the previous provisions of the Disability Discrimination Act or under the Equality Act, challenging ill health retirement provisions of a pension scheme. This is the only case that has, as far as we're aware, ever challenged such provisions. The final comment I need make on the factual side of the case is it's the point I've made. It's page 83 in the core volume. It's paragraph 8 of my the respondent's case, and I can deal with it briefly. It's simply this, that the facts of the case are agreed in the sense that what's in the statement of agreed facts and issues is agreed. There are a number of things, I've identified them at paragraph 8, that appear in the claimant's written case that go beyond what is in the statement of agreed facts and issues, and indeed beyond what the evidence was and the findings were before the employment tribunal. I've identified them in that paragraph, and I won't take up time reading them out now. Essentially, the key points are these. It is right that the claimant was working part-time for the last few years of his employment. He was doing so at his request, as I think is accepted, and indeed there was an obligation on the respondent to comply with that request under the reasonable adjustment provisions of the Equality Act. The other key point is that there was no evidence or finding about a temporary phased return to full-time work, as the claimant suggests in his written case. Whether it was a temporary or intended as a temporary or permanent return, a phased return was not something addressed by the tribunal. And certainly the evidence was that the intended phased return after his last period of absence was designed to build up to his previous part-time hours. So insofar as my learned friend relies on intention always being that he'd go back to full-time hours, that simply isn't borne out by the evidence or the findings before the lower courts. The next part of my oral submissions, as I outlined before lunch, is really to summarise the respondent's case. The issue, as your lordships and your ladyship are clearly aware, is something that can be stated fairly simply. Well, what does unfavourably mean in the context of Section 15? And was the claimant treated unfavourably in applying the correct test in accordance when the Rule 15.5 calculation was undertaken to result in his ill health retirement pension? I'll respond to the specific points made by the claimant in a short while, but the respondents say that the answers to these questions are pretty straightforward. It's perhaps a bold submission to make, given that we are here. But as
no less attractive for that.
Well, that I think is a matter for your lordship, but certainly that's the intention. It's really the case that's been put before each stage of this litigation. We accept that Section 15 was introduced to, in effect, reverse Malcolm by removing the need for a comparator. But the choice of the word unfavourably, it's an ordinary English word. As Mr. Justice Langstaff, the then president, said in the EAT in this case, it has the sense of placing a hurdle in front of or creating a particular difficulty for or disadvantaging a person. He puts it a number of different ways in later paragraphs, but that's in my submission, the crux of it. And its meaning has not caused any particular difficulty for the EAT in any Section 15 case, or indeed Section 18 case, of which certainly those on this side of the court are aware. One hesitates to rely too much on lower judgments of the lower courts and tribunals, given that none of them is binding on this court, clearly. But in my submission, and with all due respect, the views of certainly the Employment Appeal Tribunal, a specialist tribunal, are to be given some weight in this context. We also accept that unfavourably is a similar concept to detriment, but the two words do not, in statutory context, mean the same thing. They are not synonyms. Now, this is one area where it appeared from the submissions of my learned friend this morning that the claimant's case was backing away somewhat to how it has been put before. I don't need to take you to it unless you invite me to, but certainly the way the matter was put, it's paragraph 20 of the Notice of Appeal, page 20 of your bundles, is put precisely on the basis that the two words do mean exactly the same thing. They are synonyms. And that was the way the case was put below at each stage. The final part of my summary of the respondent's case is that the test, we say, for unfavourable treatment is an objective one. And indeed, that was the claimant's positive case before the Court of Appeal, and I'll take you to the relevant reference in due course. But we say even if it is a mixed subjective-objective test, which seems to be the claimant's current case, well, the answer will be the same on the facts of this case, whether you look at it under the Clark and Novikol comparator or any other application of a subjective-objective test. I just want to touch on one matter before I dive into the key points of the claimant's submissions, and it's a point that's appeared a number of times in the claimant's case, both before this court and below, and I can give you a number of examples. Before the Court of Appeal, page 394, it's in the appendix part 3, and it forms part of the claimant's skeleton argument before the Court of Appeal. I think this was the second revised skeleton argument, but it doesn't matter for this is paragraph 73.
Page, sorry.
394.
394, my lord. And it really it's the third line. As a result, i.e. as a result of working part-time, as a result his benefit was reduced. And one sees the matter put in a similar way in a number of different places on the appeal to this court. For example, page 40, which is the statement of part of the statement of agreed facts and issues, paragraph 12. It's in your core volume. Paragraph 12, in calculating the enhanced element of IHR pension, I'm just pausing there as I say, I'm probably as guilty as anyone of splitting the calculation into enhanced and accrued, but in fact the calculation is simply of IHR pension. It's not calculated in different elements. But paragraph 12, in calculating the enhanced element of IHR pension by reference to his part-time salary, Mr. Williams contends that he has been treated unfavourably, specifically through receipt of a lower pension. Similar phraseology is used in the claimant's written case, still in the core volume, for example, page 46, paragraph 8. Towards the bottom of that paragraph, 3 lines up, the payments received are significantly less than they would have been if his contractual full-time salary had been used as a multiplier. That should probably say multiplier. There we are, under the pension calculations for the enhanced element. And similarly, it goes on to page 60, I think, is perhaps the only other example I need give. Still in the core volume, still in the claimant's written case. Paragraph 51. Again, towards the very bottom of that paragraph, 3 lines up, the detriment, which again, we say isn't the right question in the first place, but the detriment was that he was unable to achieve the full payment under that scheme, i.e. the pension scheme. Now, 2 points in my submission arise from these matters and the way in which the case is put by the claimant. The first is that benefit calculation, whether it's for ill health retirement or any other purpose, is a unitary exercise. It uses a formula, in this case under 15.5, one calculation, one pension. There is no sense in which there is some higher starting point from which benefits were reduced to reach the figures calculated for the claimant. So it is to misunderstand the way in which the scheme operates and the calculation that is undertaken to refer to lower pension or reduced pension. And the second point, and it touches on a point made in the judgments of the EAT and the Court of Appeal, is that this betrays, in my submission, that the claimant's case, in substance, does rely on a comparison. It relies on a comparison between the benefits provided to the claimant and those that would have been provided to someone else in different circumstances. Presumably another disabled employee who took ill health retirement, but who was working more hours than the claimant at the date of retirement. The example given in the judgments below is of someone who has a heart attack or a stroke and is instantly disabled, as it were. The reason that example is given is that is an example that the claimant raised in the employment tribunal, and that's why that then feeds through into the judgments at higher levels. But there was no evidence before the tribunal. Again, if I need to make this point good, we can look at the tribunal's judgment, but there was certainly no finding that anyone else received ill health benefits based on a more generous calculation than the claimant. But the more fundamental problem with the claimant's approach is that it relies on a comparator, and as the Court of Appeal recognised, and the EAT recognised, and indeed the claimant has accepted in submissions this morning, that is not a permissible approach under Section 15. It is not a comparator. Indeed, the whole point of Section 15 was to remove the comparator element of the statutory test. Coming to the specific points raised against me by the claimant. As far as the intention of Section 15 is concerned, I don't think we are materially different in our position from the claimant. We have always accepted on this level and below that the intention behind Section 15 was effectively to reverse Malcolm. My learned friend has relied on a number of cases in her written case, and she took you to Hall and Chief Counsel of West Yorkshire. It's tab 11 of the authorities bundle. I don't need to take you to that unless you invite me to. I will, though, briefly take you to 2 other EAT authorities.
Well, you're going to come to what you say unfavourable treatment means.
Yes.
It says that
my Lord, I am, and I shall take that.
stoking our appetite, whetting our appetite.
I shall take. Well, I can deal with it now.
No, take your own course.
My Lord, essentially our position is it is no more complicated than to refer to the formulation given by Mr. Justice Langstaff in the EAT judgment in this case. It is an objective test, we say, it has to take into account all of the circumstances prevailing at the time, the time of the alleged discriminatory treatment, and one way of putting it, and I say that this is really guidance for tribunals in answering the question. It's not putting a gloss on the statute. Mr. Justice Langstaff put it as placing a hurdle in front of or creating a particular difficulty for or disadvantaging a person. That I don't think I can put it any better myself. By
the code uses the expression, has it changed the position of the claimant for the worse? Does that chime with your submission?
Yes, I think so, my lord. Yes, I think certainly in the vast majority of cases that would cover it. And it's interesting, if one looks at the cases that my learned friend has relied on, she hasn't taken you to many of them, but they're all in a very different context in terms of dealing. They're not dealing with pension issues; they're dealing with employment issues. But also, in pretty much every case, it's someone either had something and it was taken away from them, or partly taken away, or, again, to use a paraphrase accurately, another way Mr. Justice Langstaff put it, how others would generally have been treated. Again, it goes back to the hurdle point, I think.
It might be more accurate to say changing the position that the claimant would have been in for the worse. Because, of course, as you've been pointing out, the appellants in this case have been arguing that depriving him of the full pension does put him in a worse position. But receiving a lower pension doesn't, you would say, I assume, doesn't ipso facto speak to the question of unfavourable treatment. Receipt of a lower pension can be the consequence of circumstances wholly independent of unfavourable treatment.
Well, putting it as depriving him of the full pension, or words to that effect, is, with respect, falling into the trap that the claimant has fallen.
It's based on a premise that you say isn't established.
Well, and
he's not being deprived of it.
He's not being deprived of anything. He's been given a very generous benefit.
He's been given
the fact that
benefit.
Someone else in different circumstances might have got more, we don't know, is beside the point.
Yeah.
And to take it any further falls into the trap of relying on a comparator, and that is something that I think we both accept on this side of the court. It is not a permissible approach.
Right. So while you say getting rid of Malcolm, you say meant getting rid also of the comparator. So it didn't mean restoring the approach in Clark in section 5.1a.
Well, I'll come to that.
You'll explain that if you will, but I do wish to understand what you're saying in that regard.
Risk of being accused of whetting your appetite again.
No, just I'll wait. I'm content to wait.
I'm grateful. I think
whetting your appetite isn't an accusation; it's an acknowledgement of your.
My learned friend and I, it seems, now agree on what the correct Clark and Novikol comparator would have been. Where we disagree is as to what the consequences are of that, and I will come to that. So, intention, we're agreed, reverse Malcolm. I was going to take you briefly to two EAT authorities, and I will do that, if I may. Authorities Bundle 1, tab 14, starts at page 674. It's IPC Media and Miller. It's a case that was referred to, I think, in Hall, certainly referred to in later judgments. It's a judgment of Mr. Justice Underhill, as he then was. And the relevant passage, it's page 676, paragraph 17, and this is quoted, this paragraph in later judgments. He's discussing the background. Section 15, he says, has no precise predecessor in the Disability Discrimination Act, and so on. It does much the same job as done by Section 3A1 of that Act prior to Malcolm, so it's the reversing Malcolm point. And he then says this: we cannot see any difficulties about its meaning and effect.
Lucky for him.
Perhaps a hostage to fortune, one might say, but there we are. Similarly, the previous tab in the bundle, page 668, a judgment of Mrs. Justice, similar president as she still is, in Interserve FM and Tulekite, I think that is probably pronounced. And if one goes over to page 670, this is a Section 18 case. This is a pregnancy case, so dealing with the same formulation of unfavourable treatment, or treated unfavourably, but in the context of Section 18, not Section 15. She sets out at paragraph 10 the provisions of Section 18, and then paragraph 11 says this, about 6 lines down. Section 18 applies to unfavourable treatment and therefore requires no comparison with the treatment that is meted out to others. Whether treatment is unfavourable is a question of fact left to the good sense of tribunals. In most cases, the answer is likely to be obvious. In other cases where the answer is more difficult, and then she refers to Mr. Justice Langstaff's judgment in this case, which you are fully aware of. And I simply make this point for what it's worth. The specialist tribunals have had no difficulty, other than in this case, in applying the unfavourable treatment test.
What do you say about the case Land Registry in Houghton at tab 17? One about the sort of sick absences and bonuses and things. Was that rightly decided? Perhaps Judge Peter Clark.
My Lord, yes, His Honour Judge Peter Clark, again, a very experienced employment specialist judge. Forgive me, I was going to come to this at a later.
Oh, come later. So I just it was relied on by Miss Krasner. We do come to it later if you prefer.
I suppose, well, one point to make about this case is we are firmly in the territory of in this case, a discretionary bonus scheme, and two immediate points. One is it is in the same category in my submission as sick pay, attendance policy, those sorts of cases where something is designed to or aimed at rewarding for performance and seeking to encourage employees not to leave. That's really what bonuses are about, and indeed sick pay to encourage employees to come back to work and so on. So again, in context, it's very different from the circumstances of this case, where there is no question of the claimant coming back to work. And also it is a case where something is being taken away. There's a full bonus, and I think it was Mr. Houghton was not being given that bonus. All eligible employees received a bonus of £900, prorated, and I think Miss Horton either got a reduced bonus or no bonus at all. So
the argument, as I understand it, is that it was a bonus scheme available to everyone.
Yes,
but someone who had suffered from disability had a certain number of absences, hence the warning, hence the disentitlement. Yes. Therefore, the unfavourable treatment was the disentitlement arising from the disability.
Indeed, and going back to Mr. Justice...
By comparison with everyone else.
By comparison with someone who wouldn't.
The way Mr. Justice Langstaff put it, I apologise for repeating myself, was being treated differently from the generality of how others would generally have been treated. Everybody's eligible for this. The disabled employee, for a reason relating to disability, has absences, gets a warning. Again, different from this case. It's a warning case.
Anyway, you don't have any difficulty with that, you say?
I think your key distinction, as I understand it, is that everyone was eligible for that particular benefit, while you say that in relation to the IHR, only the disabled are.
My Lord, yes. I was going to spend some time responding to Malone and Friends' case that unfavourable in section 15 is a synonym for detriment in section 39. That was certainly the way in which the case was put before the Court of Appeal and in the notice of appeal before this court. I'm not sure it is being put in that way at the moment. We seem to have got to a very similar, and I think the way Malone and Friend put it this morning was, I don't need to go as far as saying they're synonyms. Well, if she's not relying on that, then I can go through this very briefly.
I think she says they overlap, but they're not necessarily identical.
Well, similar terms, similar concepts, I have no issue with. Synonym, I do have an issue with. I've set out in our case, we've set out in our case a number of responses to the points made by Learned Friend. I can deal with them very briefly. The starting point, we say, and we've referred you to the relevant passage in Benyon, it's tab 34 of the authorities bundle, the second bundle for your note. The starting point is different words have different meanings, particularly so when they're in the same act, and particularly so when they're in the same part of the same act. And you know already section 27 uses detriment, section 15 uses unfavourable. Must be a strong presumption in my submission that they were intended by Parliament to mean different things. The EHRC Code of Practice is relied on by Malone and Friend. With respect, in my submission, that doesn't take her case really any further, because if one looks at the relevant paragraphs that she's referred you to, they do no more than say, well, they're similar concepts, and I accept that. Hansard, I think you have my point already. It's inadmissible if you look at the relevant Pepper and Hart, and we haven't put that in the bundle, but you have the Spath Home case, tab 24 of the authorities, towards the beginning of the second authorities bundle. We say no ambiguity, no clear statement of Parliament's intention, but in any event, if you actually look at the relevant passage from Hansard that's relied on, not only is it not a clear statement of, I say, anyone's intention, let alone Parliament's, but it doesn't help the claimant anyway, because it was in the context of a clause that already used the word detriment. And it's illuminating, I say, that Parliament saw fit to change detriment from clause 14, as it was then, to section 15, the word unfavourable, and that, I say, pushes one even more in the direction of these not meaning the same thing. Similarly, the explanatory notes don't really take us any further, and I rely on paragraphs 5 and 6 in particular of the Westminster City Council case at tab 28 of the second authorities bundle. The notes really are of no assistance in construing section 15. I've already made the point this is not a section 39 case, so fascinating though Malone and Friends submissions on section 39 are, they don't really help one as to what unfavourable or unfavourable treatment or treated unfavourably means in the context of section 15. I've already drawn to your attention the distinction between parts 2 and part 5 of the Equality Act, and that is something that has been the subject of judicial comment in a number of cases. It's something I can deal with very briefly. In the first authorities bundle, I deal with these, they're more or less sequential. We can rattle through them at some speed. The first, tab 4, it starts at page 492. It's Chief Constable of West Yorkshire Police in Calm. It's one of Malone and Friends authorities, and it's one of the authorities referred to in Shamoon. It turns on to page 504, paragraph 53, towards the bottom of that page. And this was in the context of a Race Relations Act 1976 claim, and it was a victimisation claim. So again, we're in different territory. But the structure of definitions of discrimination and then other parts that render them unlawful was much the same. The point is allied to the question of whether, assuming that there was discrimination under Section 2.1, Mr. Khan was subjected to detriment within the meaning of Section 4.2c. Being subjected to detriment, or being treated in one of the other ways mentioned in Section 4.2, is an element in the statutory cause of action additional to being treated less favourably, which forms part of the definition of discrimination. A person may be treated less favourably and yet suffer no detriment. Similar position set out in tab 6, page 530, Tordant, Security and Singh, another EAT authority, and paragraph 20 is, I think, all I need to. First, in our judgment, a finding that an employee has suffered a detriment is a necessary element for a finding that there has been a contravention of Section 39.2d of the Act. That follows from the wording of Section 39 of the Act, and so on. There will, however, be no contravention of Section 39.2d of the Act unless both the elements of discrimination, less favourable treatment on grounds of a protected characteristic, and detriment are present. And so it goes on, and the next tab, Deer and University of Oxford, says much the same at paragraphs 24 and 26. Now, I won't take up time. That was Lord Justice Elias in the Court of Appeal in the Deer case. So the fact they are different concepts and different statutory gateways, as it were, through which a claim has to pass, even if it is relying on Section 39, is clear. My learned friend then spent some time dealing with the question of I think what she said was the EAT and the Court of Appeal's finding that where a scheme confers a benefit, it cannot give rise to unfavourable treatment. I can deal with that, I hope, shortly, because I say that is based on a mischaracterisation or misinterpretation of what the EAT and the Court of Appeal said. They didn't say anything along those lines. If one looks the passages that are quoted by the claimant, it's paragraph 53 of his case at page 60. That's probably the easiest place to find them. They, towards the bottom of page 60. So the Court of Appeal goes on to say that Section 15 does not protect a claimant, quotes, simply because he thinks he should have been treated better. And this mirrors the reasoning of the EAT at paragraph 29, where it was stated that, quotes, treatment which is advantageous cannot be said to be unfavourable merely because it is thought it could have been more advantageous. What's important there is the use of the words simply and merely. They were not saying in my submission that there could be no unfavourable treatment where a scheme confers a benefit, just that one needs more than a mere assertion by a claimant that he or she could have been treated more advantageously. That, in my submission, is self-evidently correct. Even on the claimant's case, that it's a mixed subjective-objective test, a claimant who thinks subjectively that they could have been treated better isn't enough. You've still got to have the objective element even on the claimant's case.
Will you be coming to tell us how that test operates?
My Lord, yes.
Yes. Thank you.
Yes. My learned friend did not take you through the many cases that she has set out in her case, so I shall take the same approach. She referred you to two of them, Horton, which I've already dealt with. The other is O'Hanlon. Again, it's a very different case from this. You have someone who was on full pay and went to half pay. It's a removal of part of their pay. That is very different from the circumstances of this case in my submission. May I deal with the claimant's submission on narrowing the scope of Section 15 and the Clark and Novacold comparator, just to come back to the point that was made a short while ago. And as I understand it, the claimant's case is, even had Clark and Novacold still been the correct approach, he would still have succeeded. We did not know from the claimant's written case what characteristics he said the comparator would have had. We now do, from Malone and Friends' speaking note, and I think we probably inferred correctly from the illustration at page 456. It's one of the new documents right at the back of part 3 of the appendix. Make a number of points about this document. The first, yes, page 456, part 3 of the appendix. The first is that it was produced for the first time, as you can see from the italicised entry in the middle of the page, on the 26th of September of this year. It's never been produced at any stage before then. Its provenance is entirely unclear, but it appears that we are agreed as to who the Clark and Novacold comparator would have been. Someone who was not disabled, would have been able to continue working, would not have been eligible for ill health retirement, would not have received an immediate pension. In my submission, there is a limit to the assistance that one can gain from looking at what would have happened if the facts of this case had been heard some years ago before Malcolm and so on, because they weren't, and no other even vaguely similar case was. But the answer in my submission, if one does take that approach, is that the figures given in the illustration simply don't stand up. The key points are these. This is a Section 61 case. No part of his case concerns his employment terms and conditions as an employee, as opposed to his pension benefits as a member of a pension scheme. So the only focus of his claim is Rule 15.5 of the pension scheme. He could, in theory, have brought a claim saying the termination of my employment was discriminatory. That could have included a claim for loss of earnings as a remedy, but there isn't any such claim in this case. What one is not entitled to do, and it seems this is something the claimant agrees with, it's paragraph 79 of his written case at page 70, and there's reference there to the Brown Bill case. You don't have it in your bundles, but we agree on its effect, I think, is that what one cannot do is look at everything in the round. One has to look at specific elements of an employment package or pension benefits. In this case, an employer can't say, for example, well, okay, predominantly male group of employees get a higher hourly rate than a predominantly female group, but there isn't any inequality because other elements of the women's pay are more generous. Similarly, one couldn't say there's no discrimination because one category are paid more per hour, but they get lower bonuses. You simply can't do that. It's not a permissible approach, and the authorities, Brown Bill included, are very clear on that. So the only question in this case is what pension benefits would have been available to the comparator, because it's a pension case, at the moment the claimant took ill health retirement, and the answer is none. Because you have a comparator who isn't disabled, isn't eligible for ill health retirement, isn't able to get any benefits until normal pension date. Therefore, no less favourable treatment even under the Clark and Novacold approach. The illustration, I'm afraid, simply doesn't do what the claimant wants it to do. You cannot include salary payments, hypothetically looking forward 28 years or so to normal pension date. Not only does that fail to focus on the date of discrimination, which is when you need to look at things, but it includes pay elements that you simply can't take into account in the comparison.
Because the only thing you can look at in your submission is the scope of the pension scheme and the way it operates.
Yes. Section 61 claim, based on the rules. What do the rules say? Is it discriminatory? You can't look at other elements of what the claimant or other employees may or may not have received. The test for unfavourable treatment we have, it seems, two options: objective or mixed subjective objective. This, I think, ties in with Merlin and Friends' submission that unfavourable treatment means the same as detriment in section 39. I don't accept that, nor do I accept that a correct interpretation of Shamoon is how, certainly I understand Merlin and Friend puts the case in respect of the detriment test. Clearly one has to start from the point of view of a claimant, and in that sense there is a subjective element to it, because to be a claimant they have to bring a claim, and they can only bring a claim if they're aggrieved about something. For example, if it's a section 39 claim, they may be aggrieved that they suffered a detriment in their terms and conditions of employment. But the essential substance of the test under Shamoon is that of the reasonable employee. You've been taken to the relevant wording in Shamoon and other cases. And in that sense, it is much like the reasonable observer in respect of contractual construction, investors' compensation scheme, Rainy Sky, and all manner of other cases.
Well, so you're saying that there isn't a subjective element. You have, what you're assessing is the claimant's assertion. So you have to see what has aggrieved the claimant.
Yes.
But then you say you look at the position of a reasonable person in the shoes of the claimant, objectively.
Yes.
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 Well, I think if I understand Ms. Grasson saying it's a looser test. I don't know whether it's being suggested that it's how the claimant feels, subject to a sort of unreasonableness, a Wednesbury unreasonableness approach. I don't know if she's going that far, but no doubt she'll tell me if she is. But unless one does go that far, the subjective-objective test will be the same as the objective test if you apply the reasonable person criterion.
Precisely, my lord.
Yes.
But in any event, that's the question of detriment. That's what Shamoon is dealing with. What it isn't dealing with is what unfavourable treatment means. And
as I understand your argument, the subjectivity of the test, of the mixed test, is confined to the means of entry. In other words, the individual has to feel aggrieved in order to launch the claim, but the claim once launched has to be judged objectively. Is that what you say?
Is that sense of grievance reasonable?
Yeah, I'm not sure that really partakes of the connotation a mixed subjective-objective test, because that's conventionally used.
Yes.
I mean, essentially, it's an objective test in your submission, isn't it?
Well, and in any event, this, so far as we're talking about Shamoon, that's talking about what detriment means, what the test is for detriment. It's not talking about unfavourable, less favourable, or any of the other parts of Part 2. And in that sense, we say that the Court of Appeal was right to find, as it did, that, and the EAT before it, that it is an objective test for unfavourable treatment. It is unsurprising, we say, that the Court of Appeal found that it was an objective test, because that was the claimant's positive case before it, and it's a little harsh to criticise the Court of Appeal for agreeing with the claimant below.
You look at it through the eyes of, or from the perspective of, the reasonable worker, is that right?
Well, in the sense that it's a claim brought by a worker, employee, whatever.
You're equating it with the investors' compensation scheme, that you look at it with how would a reasonable person in the shoes of the claimant see the matter?
With knowledge of all the relevant circumstances
with knowledge of all the
at
relevant
the time. Yes,
material.
yes, essentially. And that is consistent with the EAT's judgment in this case and the Court of Appeal's judgment in this case. And again, for your note, it's paragraph 37 of the Court of Appeal's judgment, quoting the claimant's submissions in his skeleton argument, where it was said in terms, the question is whether objectively the treatment is unfavourable. So up until this appeal, there hasn't been an issue about the correct approach to the test. My learned friend says this raises the bar, as it were, for claimants bringing claims under Section 15 and indeed Section 18, and I don't accept that. It is doing no more than effectively impose the bar at the same height it was pre-Malcolm. And it's relevant to note that Section 15 of itself is a specific provision over and above the other protections for disabled employees or members of pension schemes. Similarly, Section 18 is a specific protection for pregnant employees or new mothers. And indeed, where Parliament intended the mixed subjective objective test to apply, it said so. Section 26, harassment, does precisely that. The next part of my submissions, and I'm conscious of the time, is the question of, well, was the claimant unfavourably treated in this case? I've already set out towards the start of my submissions the circumstances as applied to the claimant when his pension benefits were calculated and the way in which they were calculated. And in my submission, looking at the circumstances at the time of ill health retirement, the answer is, in my submission, obvious. The claimant was not treated unfavourably. He was treated very favourably. Whether one looks at it in terms of a Clark and Novikol comparator, or, as I say, the proper test is an objective approach, looking at all the relevant circumstances, one cannot, and this is where the claimant's case falls down, one cannot draw a comparison with someone else in different circumstances who may or may not have got greater benefits. And I say the answer to that is the same whether it's an objective test or indeed a subjective objective test, because one comes to the objective element, and that, I say on any view, is where the EAT and the Court of Appeal got it right, and where the claimant's case falls down.
Can you just help me a little bit more on this question, what is described as being the discriminatory metric in the calculation? That is to say that here the calculation is based upon the reduced hours that working at the time that he had to retire from work.
My Lord, well, I have to say I struggle somewhat to understand quite what the claimant's saying in that regard, because I think discriminatory metric or reduced metric or whatever is not a phrase that, as far as I'm aware, was used at any earlier stage of this case.
As I understand it, the case is that the enhanced benefit was calculated on the basis of the reduced hours, despite him having worked for so many years full-time. And that is, I think that is, as I understand it, the point which is made against.
Well, two responses to that. If that is the claimant's approach, one is, certainly as I understand his case, and this is the amendment that was made during oral submissions this morning to my learned friend's written case. I think it's paragraph 65 from memory. And I think it was in discussion with my Lady Black earlier today, there was the question of, well, is there a neutral position and then favourable is above it and unfavourable below it? And where we ended up was, as I understand it, well, the neutral position is full-time pay, full period of deemed pensionable service. So in that sense, the claimant is not putting forward an approach based on some sort of averaging of accrued service as the basis for calculating the enhancement. As
I understood it, it was put both ways this morning, but maybe I misunderstood.
Well, I'd understood that the second way was being withdrawn.
Well, I think that's right because of the amendment to paragraph
Yes.
65.
Indeed. But the second point is this, looking at it as a discriminatory metric, or whatever phrase was used in the calculation of the enhanced element,
Yes.
is inconsistent with the approach that has to be adopted under Section 61, which is one needs to look at the scheme rules. Are they consistent with the implied non-discrimination rule? If not, how must they be amended to make them consistent? And what has never happened in this case is the claimant has never put forward a formulation of what Rule 15.5 should say. And I went through the way in which it operates in practice earlier. It is this unitary calculation. One gets a pension calculated on the basis set out in Rule 15.5. It isn't a separate calculation of enhanced pension, accrued pension, and the two being put together. It's one calculation.
Before you leave the neutral and on one side favourable and on the other side unfavourable, if that was the right way to look at it, what would you say the neutral was?
I think we would say that, I think our first position would be that isn't the right way to look at it. I appreciate that it's a question I've been asked.
It's difficult to look at unfavourable in a vacuum.
Indeed, and that was the point Mr. Justice Langstaff made, unfavourable, in relation to what?
Yeah.
And I can see that in a different sort of case where one is looking at, one of the bonus cases, say, or the sick pay cases, what one might be able to formulate a neutral position, and some are treated worse. But because of the particular features of pension schemes in general, this pension scheme in particular, and this case in particular, I think it's difficult to formulate what a neutral position would be. I think if we had to, certainly the treatment of the claimant in this case and the way his pension benefits was calculated is very much on the favourable side of the neutral line, wherever the neutral line may be.
Well, you've 1 minute left, Mr.
I was going to say I'm grateful for that indication. I think that would be overstating it slightly. May I deal very briefly with 3 points. The examples given by my learned friend, the UN Convention and disposal, and I'll deal with them as briefly as I can, and I apologise in advance if I go over my minute.
Well, you won't.
The examples given by my learned friend, some in her case, some appear for the first time in her speaking note, do not stand up to any scrutiny. The principal difference, the principal distinction between this case and that is that, again, all of her examples are of something being taken away, or a hurdle being placed in front of an individual. The pregnancy case, for example, is one of her new examples, and that is very much in the realm of benefits being provided with the aim of encouraging people to come back to work at the end of maternity leave in that case. We're not in that territory, and that doesn't help the claimant in my submission. In this case, no hurdle. The UN Convention, I have to confess I'm not entirely sure I understand the claimant's case in that regard. In the written case, it was a point about you had to interpret the directive in accordance with the Convention. We seem to have gone away from that now. But in any event, if one looks at its terms, it is to do with treating disabled employees or other individuals on an equal basis with everybody else. Well, that's not what this case is about. On any view, the claimant and other disabled employees eligible for ill health retirement were treated a lot better than anybody else. Disposal, clearly I invite you to dismiss the appeal. If you are minded to allow it, in my submission, those matters that should be remitted to a fresh tribunal for the reasons given by Mr. Justice Langstaff are those parts that remain not the subject of a final finding, and that, in my submission, is just proportionality. Legitimate aim has been dealt with below. It hasn't been appealed. The my learned friend says you have wide powers, but the respondents have not been given the opportunity to respond to any submissions seeking to overturn the legitimate aim finding before this court, and on that basis, at its highest, even if the question of proportionality only should be remitted.
Well done.
I'm sure I'm a little bit...
Mr. Margot? Ms. Krasnod?
The first point we make is that we found it interesting that Mr. Bryant seemed reticent to say what the actual test was for unfavourable treatment under section 15(1)(a). If it's maintained that it's purely an objective test, taking into account purely that perspective of the objective bystander, and not taking into account the perspective of the particular victim at all, that test, which indeed would be a purely objective test, would run counter to the provisions in the Equality Act, which I took you to before lunch, for no reason whatsoever, and would be, in my respectful submission, a huge step backwards for the rights given under section 15, particularly when one bears in mind that there is an objective justification defence available for this kind of discrimination. There can be no reason why one would put the threshold so high. And indeed, it's a narrowing of the test from that which Lady Hell fought for in her dissenting judgment in Malcolm. And in particular, we say that section 15 was meant to adopt the same scope as Her Ladyship argues for in that dissenting judgment, albeit not via the same test.
Where does she say it should be a subjective test?
No, she argues keep Clark and Novacold, and we
Yes.
say that under that less favourable treatment test, what you're doing there under less favourable treatment, you take into account the perspective of the individual victim, as we saw through what the Code of Practice guided us to at paragraph 3.5 in the Code of Practice. That's at Appendix 3A.
They're relying not on what she said, but on the Code of Practice.
Well, it's not, in my respectful submission, it's not controversial what the test was under the
Well,
previous
I'm
test.
sure it isn't, but I'm not as familiar with it as you are. I'm just trying to find where one looks for the subjective test,
Well,
as you said.
My Lord,
established.
she didn't need to go to that particular measure in her judgment, because what she was doing was arguing for what the reason
So
should
is it
be.
in Clark and Novacold?
Yes, the example you refer to in Appendix 3A is of a manager having appraisal duties removed from her. And you say she feels demeaned. But that example could equally fit the respondent's case, because her feeling of being demeaned is the gateway. And then one asks subjectively, would a manager reasonably feel demeaned if her male colleagues had this managerial duty and she didn't? And
Well, my Lord,
one might readily say, well, yes, they would.
I believe the difference between the two of us is that I say what the mixed subjective-objective test is that you start off by looking at how did the victim react to this treatment, what was his or her stance, and then you apply the reasonableness test to that. That's why in St Helens...
But what is the reasonableness test? Sorry to interrupt you.
So sorry.
What is the reasonableness test? Are you saying it's a sort of Wednesbury irrationality test, or are you saying you then, having ascertained her sentiment, readily understandable in that example, you then ask, would a reasonable employee in her shoes take the same view?
It's as simple as this, I suggest. One says, look at the perception of the victim and then ask, was it reasonable for her or he so to perceive?
So it's a sort of Wednesbury type test, is it?
Well, what you have to, I don't think it goes as far as saying it's a Wednesbury test, and I wouldn't want us to have to insert another version of that kind of reasonableness into it.
I think if you're importing the Wednesbury irrationality test, it would involve asking the question, was the reaction of the claimant so unreasonable that it could not have been shared by any reasonable person? You say, no, you don't need to go that far. All you need to say is the reaction of the individual reasonable?
Quite, my lord. And the reason why I emphasise that is because you do look to this particular victim's perception as opposed to any worker who might experience such treatment.
Yes, I'm sorry, my question was actually far more innocent than that. I was just trying to, because we looked at Shamoon, and then we were very helpfully given by your junior some references to the St Helens case. And I went and looked at that for guidance, and we find there what seems to be an objective test by Lord Justice Brightman referred to. Then we have Lord Scott's rather different subjective test. And then I tried to see what Lord Newburgh had made of all that. And I ended up, my trail went thin, so I... But they were dealing with detriment anyway, so in a sense that was a different point.
Well, that's why, my lord, I took you back to the head note in St Helens, which sets out at page 920. Can I just refer you to the second paragraph under the holding, where it says, halfway down that paragraph on page 920, secondly, under the victimisation provisions, it was primarily from the perspective of the alleged victim that one determines the question of whether or not any detriment had been suffered.
I see, and you say that's supported by the judgment. All right, well, I can look at that for myself, thank you.
Thank you, I'm very grateful. So that question hasn't been answered with respect by the respondents. Why should section 15.1a have this different test from the other provisions we've seen? I need to clarify a point that's been made about whether we've changed our case or not. It's always been said by the claimant, ever since the employment tribunal, that at the end of the day, what he seeks overall is a declaration in the alternative, that is, after objective justification is applied to this, in that either the enhanced element of his pension is determined on a full-time basis or alternatively on an averaging basis. I haven't got time to go through that in detail, but it's paragraph 18 of his skeleton argument for the employment tribunal at appendix 3, page 441. So I refer you to that. Interestingly, it was said that when you're looking at what unfavourable means, you should just apply it as an ordinary English word and take it as its most simple meaning. However, when one's looking under the Equality Act at what this specific provision means, one has to bear in mind that there were provisions which predated it, and also that there's a whole scope of provisions providing complaints under Part 2 across that part of the Equality Act. So we can't simply have that term in a vacuum. And I think the respondent agrees it has to be looked at in all the circumstances. And those circumstances and context include the other claims, Section 26, Section 13, and so on. It's suggested by my learned friends that we're wrong in trying to determine unfavourable in terms of a lower pension or something other than it would be when a pension is a calculation that starts from nothing. Well, it's clear in my submission that Mr. Williams is saying if you take away the disability-related metric here, which is ignoring the fact that he only worked part-time because he was disabled, then you would use a full-time metric in the pension as opposed to the reference to the final salary in Rule 15.5, and indeed his pension would be greater than it is. So when he refers to a lesser payment, that's in comparison to if the disability tainted metric is removed. And it's perfectly possible for him to put his case like that, because what we're looking at under section 15.1a is unfavourable treatment in consequence of something arising as a result of the disability. And here that something arising is he couldn't work full time. So we're not relying on a comparator. That's not necessary at all. We're not relying on another kind of disabled employee. And we clarified before lunch that that would be a claim under section 13, direct discrimination. And that's never been brought. The only reason for Mr. Williams using the Clark and Novacold comparator is as a litmus looking at whether the scope of the duty has narrowed. And his case turns on the fact that he says he got less than if that discriminatory metric was removed. And despite Mr. Bryant maintaining that this was an extremely advantageous scheme and how Swansea University pension scheme did not have to provide everything that it did, we say that totally bypasses the question that by using final salary as part of the calculation, the claimant did experience unfavourable treatment as is understood by that section. And the respondent has not actually said why an objective test, in contrast to the other kind of tests, is appropriate here. Why is it that section 15.1a requires a more stringent scope of disadvantage? You've simply not been told why that would be. The other way the respondent argues that the examples we give in our case aren't relevant, because he says, oh, in all those cases something is taken away, and where we've looked at schemes such as bonus schemes or statutory maternity leave schemes, those are all to keep someone in the workplace. Well, in our submission, that simply ignores the fact that in those examples, and indeed in specific cases, you're looking at situations where there is something which is discriminatory and taken away from the individual despite there being overall advantage. So our maternity pay example remains a good one, we say, and the very fact that it may have been beneficial overall, even such as this pension was, does not mean that you cannot look at a disability-related element or calculation within the whole. One wonders what the respondents would say if there was a pension rule in this pension which said something such as, well, one can only have 50% of the lump sum if you were female. Would one ignore that kind of reduction because overall one was benefiting? That would be, we suggest, an absurd result. And when looking at all the circumstances of the case, the respondent says to you, the reason why you must apply the objective test is because you look at all the surrounding circumstances. Interestingly, that ignores the perspective of the victim, perhaps the most important person to take into account as one's starting point when looking at what this protection was aimed to do, following the Malcolm decision, the very fact that it was inserted back into the Equality Act with carefully drafted provisions to prevent there being confusion with direct discrimination and to prevent a Malcolm situation recurring. When asked about Land Registry and Houghton, we suggest that Mr. Bryant had no real explanation for why that was a different situation. It's still something positive being given, and to the answer whether or not it goes to everyone or just to a selection of the working population here, it makes no difference in our submission. In Williams, Mr. Williams could indeed have obtained a greater pension had the disability-related part of the calculation, that is, final salary, which for him was part-time salary, been replaced with full-time salary.
I think we realise that.
Am I up to
No,
half an hour?
you've got 13 minutes left.
Thank you very much. In terms of whether or not the case has changed from how it was put below, below it was emphasised to the Court of Appeal that it should be a mixed subjective-objective test. And that's clear because of the emphasis that was put to their lordships on the case of Shamoon. And you'll recall the paragraph 43, I believe, where Lord Justice Bean says, I don't think it's about Shamoon. We submit that he didn't understand the point that was made, which was Shamoon was at the forefront of the argument because there it was being suggested that it was vital that Section 15.1a had this mixed subjective-objective test. That's why it said it was at the forefront of counsel's argument. Turning to the point in our illustration, we say that under Clark and Novacold, one looks at all the circumstances overall. And to ignore what happens to someone in Mr. Williams' shoes who was not disabled is entirely illusory and misses out the circumstances of that situation. Now, Mr. Bryant was keen to tell you of the difference going forward to Mr. Williams in terms of his financial advantage on getting the pension. But in a case where he is being dismissed, is accepting termination of his employment for reasons of incapacity, the very fact that he can't work any further goes hand in hand with the fact that had he not been disabled, he would have carried on with his full-time salary. And we say less favourable treatment would have been made out under the previous test.
So is this your illustration at page 456?
It is, my lord.
That's
yes.
that's new, isn't it? It's come up.
It's not. It wasn't used before.
Yeah.
No, not in the Court of Appeal below.
I mean, he says, well, it doesn't help you because the person who carried on working wouldn't have been entitled to a pension at that stage.
We've always accepted they wouldn't be entitled to a pension. The difference between us is that we say it's entirely appropriate to look at what would actually happen to that individual, because that's what would have happened to Mr. Williams had he not been made incapacitated from his job by reason of his disabilities.
But he says we were looking at the thing at that point in time.
Well, I've addressed the court before lunch about the fact that by 18 months after the retirement of Mr. Williams, the hypothetical comparator bypasses him in terms of what happens from then on. But we say one has to look at that situation in all the circumstances of its case, including the fact that getting your ill health retirement pension and your lump sum goes hand in hand with the fact that you no longer are deemed fit to work. You're incapacitated and your earning capacity, by virtue of your disability, has been taken away. Interestingly, we note that the respondent hasn't answered the questions we posed about would it be the case that it would be that to require care at least for the accrued element, and neither has it been suggested that the enhanced element is any different from the accrued element. We say there simply is no justification for treating those parts of the calculation differently. They've always been explained by the respondents as the accrued element and the enhanced element, and you'll see that in the skeleton arguments leading up to this hearing, which are from the courts below, which are in Appendix 3 before you. So this is not a case of Mr. Williams saying, I could have been treated better. The discriminatory metric here was the part of the calculation which inserted his final salary. That clearly was an unfavourable treatment for Mr. Williams for the reasons we have set out.
Can I just test it?
Yes.
By slightly changing the facts, but on the rules of this scheme. You have to have worked for the employer for 2 years before you can come into the scheme. Suppose that he had to stop because of his disability short of the 2 years. On your argument, could he say that's unfair to exclude me from the scheme?
Well,
It's unfavourable treatment.
Well, my lady, there have been cases where length of service is affected by career breaks, such as for maternity leaves and other caring responsibilities. And there have been challenges to whether length of service provisions are indeed lawful in those circumstances.
What do you say about this rule and your argument? Is that a necessary extension of your argument?
Well, suppose they said we're only taking into account full-time service for the qualifying period for you to qualify. If they did that and ignored part-time service, which might be occasioned by disability, we absolutely would say that was unfavourable. Or if they ignored, for example, service when one was off sick per se. But whether it would be justified or not, my lady, is an entirely different question. And that would be for the respondents to put forward and argue that to have such a qualifying period was a proportionate means of its achieving its legitimate aim. So we're not saying at that stage the respondent wouldn't be able to argue that they were justified. We don't know. It would depend on what the outcome was, firstly, on unfavourable treatment. And that's vital to remember, my lady, that however generous the pension scheme is, the respondents have an opportunity to put all those points forward at the second stage under section 15(1)(b). So we respond to the case conclusion reached by the respondents in our speaking note at pages 20 through to 22. My Lord Kerr, how much longer do you calculate I have left? I just don't want to run out of time on addressing you on disposal.
Don't worry, I will let you know in good time.
No.
You've now got 6 minutes left.
I'm very grateful for the indication. Thank you. So looking at page 103 of the respondent's case, it's the very end of it. In terms of little a, we accept that the concepts of unfavourably do not mean the same. We don't have to show they mean the same. Our cases, they mean similar things, and you can take advantage of when interpreting unfavourable from what similar terms mean. We've addressed you on the objective test. We fundamentally disagree with that finding and what's been said by the respondent on an objective test. In terms of what circumstances should be taken into account, looking at C, but of course the circumstances of the claimant must be taken into account as well. And looking at C and D together, while we agree that getting the pension is an advantage, we here are not saying that the pension overall is the unfavourable treatment, it's the calculation using final salary within it. And we say that one has to remember the fact that the condition suffered by the claimant has meant he won't work again, no longer able to earn a salary. We've addressed you on the Clark and Novacold comparator already. And looking at little e, we simply disagree as to whether the claimant was treated unfavourably regardless of what test you apply. And we say what the factors the respondent urge you to bear in mind here should be factors for the objective justification part of the test. What Mr. Bryant does is ask you to bear in mind all the factors which he should be putting into his proportionality arguments. There's nothing to say here that it wouldn't be Parliament's intention that a disabled employee can challenge these kinds of schemes, but one has to remember that Section 15.1 has two sides to it. The respondent, again, ignores the second half. As to little g, the claimant here has had a hurdle put in his way. He doesn't have to start from a position where, for example, he's had a job and he's been dismissed from it. That's not what the provision requires. Rather, he's been treated disadvantageously. That was part of Mr. Justice Langstaff's gloss on the statute, and it applies to the claimant. And if one wants to use the term hurdle, for him the hurdle was having to comply with that term final salary. He couldn't comply with the final salary without his disability-related work being taken into account. We disagree on whether we'd succeed under Malcolm. I've addressed you on that. And we suggest there is a slight danger in your taking heed of the words ordinary meaning in little I. What my ordinary meaning could be very different from the next person's, which is why the Code of Practice exists in my submission, in order to provide guidance as to the correct threshold to be applied. I've already addressed you on the convention and why we say that requires the mixed test. In terms of disposal, where we disagree is with respect to what happens with legitimate aim. The Court of Appeal didn't deal with the claimant's appeal from the EAT on the question of legitimate aim, because that was academic in the light of its decision on unfavourable treatment. So if we are right on unfavourable treatment, then Mr. Williams has lost the opportunity to dispute the legitimate aim, which we're contending ought to go back to the tribunal. It's correct to say that we didn't appeal that point from the Court of Appeal because it didn't form part of the Court of Appeal's judgment, but we make the point at paragraph 5 on the last page of our note that neither did the respondents cross-appeal the Court of Appeal's decision to set aside the EAT order for remission on justification if the Court of Appeal was found to be wrong on unfavourable treatment. We say that the interests of justice do require that legitimate aim is reassessed again in light of what is identified as the correct unfavourable treatment, and it would be in accordance with section 45 of the CRA to remit legitimate aim as well. It would do justice to the case for both legitimate aim and the question of proportionality to go back to the employment tribunal following our being successful on this appeal. May I have 1 minute just to check with
You do have 1 minute, and you may have it, but no longer.
My lords, my lady, the only point it remains to say is by narrowing the scope, by adopting an objective test, would be a retrograde step for section 15(1)(a). And Mr. Williams asks you to allow his appeal. Thank you very much.
Thank you very much. And we're very grateful to Council for their very helpful submissions, and grateful to those who helped Council make very helpful submissions. We'll reserve our judgment and deliver it in due course. Court is now adjourned.